SJC-12930, Commonwealth v. Washington, Pearson.
Mr. Crane.
Good morning. May it please the court, Edward Crane on behalf of Washington Pearson. The issue before the court here is the proper application of the independent source doctrine under Article 14. It's the defendant's position that the doctrine is correctly applied by looking to whether the involved officers were influenced to seek a search warrant by the observations they made during the unlawful entry. This application.
Mr. Crane, I'm trying to figure out what's more defendant friendly, the one they use or this. It's kind of a tongue twister. Can you parse it out for me as to whether you really want to win this case?
Sure. I think that I think just looking at the facts of this case, I think that the doctrine that we're arguing for is certainly more helpful to the defendant than the.
Well, I know on this case, absolutely, but just as far as how you compare them, because I don't want to change the law if it's going to hurt defendants.
Well, certainly not. I think that so I think if we're more generally looking at what doctrine is going to protect more defendants, I mean, the way I look at it is the doctrine that they've adopted is really only going to help defendants in the very rare instance where you have a police officer who testifies that he subjectively intended to seek a search warrant despite not having probable cause, and then a motion judge somehow crediting that testimony. I would say that that's a very rare instance, whereas the doctrine that the defendant wants applied would help the defendant in situations where the police officer does not subjectively intend to seek a search warrant, but does have probable cause. I think that's a much more likely scenario. That's going to arise in many more instances than this very rare scenario that I think the appeals courts somewhat dreamed up. I mean, this is sort of a hypothetical situation where a motion judge is going to credit a police officer.
Your standard is, was it objectively reasonable for the police officer to obtain a search warrant without the information obtained, i.e. the prior legal search, right?
No, that's the standard that the appeals court has adopted.
I'm sorry, I have them conflated. Was the decision to obtain a search warrant prompted by the illegally obtained
exactly
information, which is subjective, right?
It's subjective. I think it does get a little confusing in the use of objective and subjective, but essentially what we're arguing for is you have to objectively look at the words and deeds that the officer, his words and deeds to assess his subjective intent, whether he intended to seek the search warrant or not.
Well, what about when the police officer says, "No, I was going to get one anyway"?
Well, you have to look objectively at the facts and circumstances. I mean, certainly, no judge is required to simply credit a police officer's testimony to that effect if all of the, his actions and then his other words contradict that.
So I think that's what the appeals court struggle with is the ability of the police just to say, not a big deal. I wouldn't have done it.
Well, I just don't.
Because the second prong is easy, because you're going to excise the illegality anyway and to determine probable cause, right? That doesn't get us anywhere. So I'm just struggling with the subjectivity and the ability of the police to always satisfy that and whether that truly protects defendants in the way you're seeking to do so.
Well, I see it as a.
I mean, I think you might be right on the footnote, and that kind of gets read out of the cases, the Jesus footnote. No, I think I agree with you, but I'm just wondering if we're going to cause more harm than good by ruling your way in this case.
Or I'm not sure what ruling your way in this case means, as a matter of fact. I'm really not sure what it means. If we can start from the fact that the Supreme Court says that there are these two prongs, right? Have to be satisfied. And then yes. You're saying Massachusetts law has, with the first instance of the Pearson case, Pearson 1 read out prong 1, right? And you're saying that is not more protective of defendants than it would be to keep it in. So you want the United States Supreme Court case basically to govern for Article 14 as well as its own search and seizure doctrine, as well as the United States Constitution. You want to say Article 14 of our Constitution is also most protective of defendants when in comparison with the Supreme Court doctrine, right? Two prongs.
Yes, and I think that's where this case does get quite confusing, in that it's sort of a situation that's completely unique in that the defendant's actually arguing for the federal constitutional standard to apply.
Yeah, that is on.
I mean, the court in Pearson 1, frankly, applied this, a new state constitutional standard to defeat the defendant's claim, which, I mean, it's sort of unheard of.
It said it was more protective. It said at the time the court was saying it was more protective of defendants, right? To do it that way.
They do say it's
right?
more. They do make that claim, but I don't think that really, when you really look at it, that's not accurate.
But is that right? I mean, because there are two parts to both the federal and state standard. We both have the same probable cause on the second part. The issue is whether there's a subjective standard on the first part or an objective standard on the first part. And it gets even more ridiculous to fight over this in certain ways because there's an objective component to analyzing the subjective one, even under the federal system, right? So is this kind of like, angels on pinheads that we're fighting over here? And as Justice Gaziano points out, I mean, it's a little harder to meet that objective standard in the first part normally than a subjective standard, because the cops are always going to say they would have gotten it. So are you hurting yourself here over a distinction without much of a difference?
I don't see it. I certainly don't agree that it's a small distinction. I mean, if this test is applied in every instance where a police officer has no real intent to seek a search warrant, but does have probable cause and goes ahead with the search, I guess you could refer to it as a confirmatory search. In every instance, this test is done.
That's not what Pearson 1 said. Pearson 1 said, in the first part, we look at whether an objective police officer, an objective standard of whether a police officer would request the search warrant. Isn't that what Justice Cipher was saying in Pearson 1? As opposed to determining, and it may be a slight distinction between what the feds do in the first part, which is whether these particular officers would have done it. But it isn't, as Justice Gaziano said, more protective for you because we're going to raise the standard to an objective one on the first part. So it seems like the state standard is more protective on part one than the federal one is. It may be a little different, but isn't in the end of the day more protective?
I cannot see how this is more protective to a defendant, because what's going to happen is there's going to be way more instances like this case where the police don't really they haven't formed the intent to seek a search warrant, but they do have probable cause. So in every single instance, the test adopted by the appeals court is going to help the Commonwealth. It's going to because despite the fact that the police don't intend to seek a search warrant, it's going to insert this objectively reasonable police officer in their place, in the place of a police officer who frankly has been found to have acted unreasonable. And then,
Mr. Craig, on the objective one that's used by the appeals court, is it more like we're looking at should they have? Is it objectively reasonable? Should we have expected them, objectively speaking, to obtain a search warrant at the moment they entered?
well, I think that's a great question.
That's what we're really looking at, right? Because we want them to get search warrants when they have probable cause, and we don't want them to do this post hoc, yeah, I would have gotten one anyway, analysis. But isn't that what we're kind of looking at?
I think that question sort of gets at the heart, I think, of where the appeals court got off track on this case, because we do generally look when we're assessing police conduct, we do look at that objectively. But the problem is, in this test, we're not assessing police conduct. We're not saying whether police conduct was reasonable or not. The whole point of the independent source doctrine is it's really a factual question. Would the police still have got this search warrant if not for their unlawful entry? And on that question, the best way it's basically making a prediction. What would have happened if not for the unlawful entry? And I think, again, when the appeals court and they mixed the assessment of police conduct, which certainly is always objective, with what the independent source doctrine is not, does not assess police conduct. It's an exception to the exclusionary rule, and the whole point behind it is, you've already found that the police have acted unreasonably in some aspect of the case, and the question is, does that unlawful conduct, did that taint the subsequent securing of a search warrant? So, I think that's sort of where the confusion came from. When we're looking to predict.
Can I just ask you? I'm trying to figure out. All right, assuming that you're right that the federal standard is more protective, and we should always look to the subjective. How do you isn't the best you can get a remand and have a hearing to see if these officers actually subjectively would have sought a search warrant?
Yeah, so I'm not, I'll admit, I'm not certain either way on the exact remedy here, because sort of the procedural circumstances that led to this are somewhat unique. So what I would say is I think that it really is the Commonwealth's burden to establish that there's an exception to the exclusionary rule that applies. And nowhere in this case has the Commonwealth made any attempt to meet that burden. So I think the court could say, look, the Commonwealth failed to meet its burden, and that the motion to suppress therefore should be allowed. But I certainly wouldn't say that, I wouldn't quibble if the court said, no, this needs to be remanded, and really the correct test needs to be applied. And the factual question as to whether Detective McDonald was influenced to seek a search warrant by what he saw during the unlawful entry, that's the critical question that needs to be answered here. So again,
do you think that there's any real possibility, given the extent of this crime spree and the amount of evidence they have here, including that Ms. Johnson left her license at the burglary, that they wouldn't have gotten a search warrant here? I mean, is there any? I mean, this is a tough case on that. Yeah, this isn't one of those, wow, they stumbled on some evidence illegally. They've got a whole pile of it here.
Well, I think if you look objectively at the, at what Detective McDonald did, I don't think, so on the first step though, I think we can't be confused and say that it just depends on the commitment to the investigation. I think that is not the analysis. It's the commitment to securing a search warrant. Did he show commitment to securing a search warrant? And here, he had opportunity to seek a search warrant, he didn't. And I think even more telling is you look at what he's compiled in the affidavit before this entry. There's nothing in there to indicate that he even knew where Mr. Pearson lived. All they have prior to this entry, there's no evidence as to how they even knew that he lived there or why they showed up there. The only thing they have is that his car was parked somewhere in the vicinity. That, according to his affidavit, that's all we know. So to jump then to the conclusion that, oh, he was absolutely committed to securing a search warrant for this home, I think it's a huge jump. Certainly, he was committed to the investigation, but I think that's where, I think this comparison to Danny Reagan from Blue Bloods is appropriate, because look, if you just look at the commitment to the investigation, yeah, he's always committed, but the question is he committed to doing it by the book? Is he committed to getting a search warrant? And I think those two things, commitment to the investigation versus commitment to a search warrant, are two different things.
Mr. Crane, why don't you asking to have your cake and eat it too, and that the first prong is has to satisfy both subjective and objective.
Well, I think it's, frankly, I think the test is really quite well laid out to getting at, again, the question in this doctrine is, what would these officers have done if not for the unlawful entry? Would they have gone and sought a search warrant anyways? And I think the first part of the test really is, the question is, would they have sought the search warrant? The second part of the test is, would the search warrant have been granted? So I think that the two-pronged test is actually, I think it's very well fashioned for this particular inquiry. So I think there does need to be, I mean, it does go back to, what's the whole purpose of the independent source doctrine? The purpose is, it's a factual question. Would these officers still have obtained this search warrant without this unlawful entry? And I think that's why the two prongs, looking at both, what would the officers have done? And then the second question is really, what would the clerk magistrate have done? Would they have granted the search warrant?
Absent the illegality of the search, of the entry into the household, putting that aside for a second, do you disagree or agree that the evidence was sufficient to provide the police with probable cause to get the search warrant?
I think the evidence before the entry would have been certainly insufficient, because again, nothing before the entry. If you read the affidavit, and I don't even think you have to even look, it's not really looking closely at it. It's just simply, when is the first time they even mention 471 Broadway? They don't mention 471 Broadway until there's a discussion that his car is parked somewhere near that location, and then it's completely unexplained as to why they even go to this house. From what I can discern from the affidavit, it sounds like they knew his car was parked near there, so they went over there with what they thought were arrest warrants. And who knows what happened when they got over there? Maybe they were just looking around and they saw her out in the front yard of a house. She goes inside the house and they say, let's go get her. We got these arrest warrants. So this idea that somehow they were narrowing in on 471 Broadway, and they knew that they lived there, and that this was inevitable, that they were going to seek a search warrant before entering the home, I think it rests on a lot of speculation.
You don't think there was probable cause, in other words?
I'm sorry?
Absent what they might have gotten by virtue of having been there, you don't think that there was probable cause before that, before the entry?
There's absolutely no way they had probable cause before the entry. And that's simply because, again, they had probable cause to arrest. I think absolutely they had probable cause to arrest these two, but probable cause to search the home, that there's nothing in this affidavit that connects the home to the defendants at all before the entry. There's no explanation as to why they even entered the home.
Okay.
Did any of this stuff come up during the first motion to suppress? Was it, the two-prong test, and whether or not there was a subjective, they would have subjectively gotten the search warrant?
No, none of this came up at any point, and this is why I think, I do think the defendant has suffered from some procedural unfairness here, because this whole independent source doctrine was applied sua sponte. In the initial motion hearing in Norfolk, it was applied sua sponte. There was no discussion about applicability of the independent source doctrine. The judge didn't bring it up. The Commonwealth didn't argue it. It was solely a question as to whether the arrest warrants were there at the time of the search. And then, on appeal, then there's no discussion about whether Article 14 has a different test as opposed to the federal test. And then, again, this is the Commonwealth's burden really to argue that an exception to the exclusionary rule applies. So I think if we're saying that, the defendant should have, not only argued that he has met his burden, but also that the Commonwealth hasn't met its burden, I think that it's tough to hold that against him.
Well, we can't fault a judge for applying the law, right? But let me ask you a different question, Mr. Kane. And this might be a Hail Mary, but in your research, have other states reformulated this test to be more protective of defendants that we can look to?
No, I haven't found any state that applies it differently from, how Murray, how the Supreme Court applied it in Murray. It seems like there's pretty much a complete agreement that this is a two-part test.
And we're the
So
outlier on this.
I do think that this is an outlier, certainly.
Okay, thank you, Mr. Crane. Any further questions? Mr. Farragut, please.
Thank you.
Thank you. Good afternoon. If it may please the court, Timothy Farrader, Assistant District Attorney from Middlesex on behalf of the Commonwealth. My brother and I agree that De Jesus and Murray require a two-pronged test for the independent source doctrine. Where we disagree is how that impacts this case. This claim that the defendant raises on appeal was not raised before any judge in Middlesex, and no ADA in Middlesex was given notice to respond to it. The only evidence of what was actually raised in Middlesex is from Judge Laureate's opinion that the defendant simply challenged probable cause, and that he challenged that a Cambridge police officer couldn't make a search without applying for a search warrant in Middlesex County. Justice Laureate gave the defendant the benefit of the Norfolk finding that there was an initial illegal reentry, struck that section, and then did the probable cause analysis. There was no pleading from the defendant that's before this court or before the appeals court in Pearson 2 that the argument being raised on appeal was ever raised in Middlesex County. I think therefore the appeals court correctly applied De Jesus under the substantial risk doctrine and looked where the detectives from both Brookline and Cambridge were clearly committed to this case, that it's unreasonable to think that they wouldn't have sought a search warrant. This is a similar approach that this court took recently in a case that came out after the briefing, Fernandez.
Mr. Farragut, Justice Budd asked a question about sort of the procedural posture. I'm now getting confused. Did the independent source doctrine, how did that get into the case? Did somebody save the case on the independent source doctrine even though it hadn't been brought up? I can't remember the procedural posture of this.
So that's in Judge Fishman's opinion from Norfolk. The transcripts from Norfolk and the pleadings from Norfolk aren't part of this appeal. So I can't confirm Mr. Crane's assertion that was brought up sua sponte. It's in his opinion. I don't know if the Commonwealth brought it up or not. So I can't answer that question because the Norfolk pleadings and transcripts aren't part of the Middlesex case.
Judge Fishman's decision relies on the independent source doctrine. So you win. I'm concerned about the cases where we come up with a new rationale on appeal. That's not the issue here. Judge Fishman, who's an astute criminal law judge, he's the one who discerned that the independent source doctrine came into play. Is that right?
Correct. In the Norfolk case, and the defendant filed his motion to suppress in Middlesex subsequent to the decision in Norfolk.
Wait, but before you go to the Middlesex, in the Norfolk case, did Judge Fishman apply that two-prong test where you have to see the subjective and then the whether there's probable cause?
It is not in his opinion. But again, I don't know if it was a genuine issue raised by the defendant below, similar to De Jesus, where it wasn't a genuine issue, it wasn't raised below. So where the transcripts and the pleadings are.
But none of it was raised. None of this wasn't an issue in that case. So
it wasn't an issue in what way, Your Honor?
Right. Okay.
You don't dispute that Mr. Crane has it right that De Jesus on footnote 11 includes the two-part standard, correct?
Correct. No, there definitely should be a two-pronged standard, and I think through inadvertence, some of the opinions have dropped one of the prongs. There are cases. There are several unpublished appeals court decisions that keep applying Murray correctly, but published opinions seem to be only focusing on the first prong. I don't know why that is. I think in most cases it is fairly obvious that they were going to get a search warrant. So I don't think
the danger of putting something in a footnote.
It is.
But when you say there's two prongs, you're saying that the first prong you agree is the subjective prong, or are you saying it could be objective?
I think it's usually most courts express it as subjective. The First Circuit in Judicial, I'm not sure if I'm saying that correctly, instructed that trial courts in that circuit to also look at the totality of the circumstances and not just focus on an after-the-fact assurance. I mean, I think Justice Henry in her dissent in Pearson 2 got it right when she said it's really a distinction without a difference.
Okay.
It's the same reasons why an officer would be subjectively credible because he had done X, Y, and Z are the same reasons why he would be objectively reasonable because he did the same thing. So
So did Mr. Crane miss a hanging curveball when I asked him if the first prong should be both objective and subjective?
No, I think he squared that one up.
I
think-
I love baseball.
I think it is a subjective analysis, but because the problem with this test is you're answering a hypothetical. What would someone have done if X had not occurred? So to get to that subjective, I think you have to look at the totality of the circumstances and see whether or not that's credible based on everything that had happened. Do we really believe the officer would have gotten a warrant? In this case, it has to be a substantial risk analysis. There's not pleaded at all this way in Middlesex. I know that the defendant keeps pointing to the Commonwealth's burden, but there's first a pleading burden under Rule 13 that didn't come close to being met in this case, and no one was put on notice in Middlesex that this was an argument that was going to be made until appeal. And looking at everything that Brookline and Cambridge had done together, including in this case it's kind of rare in the independent source doctrine, the illegal entry is a technical error because a warrant wasn't done correctly, but they had probable cause assessed by a neutral and detached magistrate. They went to the house believing they had a search warrant. It's clear they knew where
They had an arrest warrant.
Sorry, arrest warrant, believing they had an arrest warrant. It's in the search warrant affidavit. One of the first things they do is ask for consent. And when they don't get consent to search the house, they haven't really seen much in the house. If they didn't already know it was going to be there, they go and seek a search warrant. And
What did the entry add? I asked this of your brother. I asked to find out whether or not you thought there was probable cause to get a search warrant, even before the entry. Was there?
The entry, I believe the only thing they viewed in the entry is they viewed a couple of the things that she had purchased at Macy's.
Okay.
But
So
they
what
already,
does that mean?
I think it means very little in this case. They already knew, they found, I mean, they had already done a lot in this case. They had found Johnson's ID at one of the scenes. They had the surveillance cameras from the 4 stores where they made the illegal purchases. They had the photo array with the positive ID. They contacted Lynn, who did the master name search, and found that Johnson and Pearson were in Lynn the night before they went to effectuate the arrest. That his car was still there the afternoon and night before. And when they knock on the door, Johnson is the one that answers the door. That's also a legal observation before the entry. So I think the probable cause in this case, before they even made any entry, was overwhelming. I know there's also an attenuation argument. I don't even think the court has to get there. The probable cause was more than sufficient before they ever
Okay.
viewed
So let's
it.
assume that there was probable cause to get the warrant, search warrant. Suppose though that the evidence showed also that the police officer would never have done that, absent the entry. He was really somehow something the entry. Had he not done the entry to make the arrest, thinking he had the arrest warrant, he would not have. He wouldn't have gotten the search warrant. I mean, so I don't understand what the role of the first prong is, to tell you the truth, in this analysis. If the second prong is that there would have been enough, objectively, to get it without the entry, then what difference does it make what the police officer would have or would not have done? I don't understand. Is that enough to sort of knock it out of the park? Is that enough to take it away from the Commonwealth if the police officer didn't somehow satisfy that prong?
I mean, if the police officer testified that he would never have done the search warrant except for what he saw, I do think that's the purpose of the first prong. And I think there's also
That would take away from the Commonwealth.
looking at the totality of the circumstances, and after the fact assurance helps the courts to decide whether or not the officer is being credible. So I
Right.
think that's the purpose of the first prong.
We're trying to encourage search warrants, not discourage, correct?
Correct. And I think this is
In early, when they have probable cause to apply for search warrants.
correct. And I would say that, you know, I know the brother brings up the issue of possible confirmatory searches and going around the search warrant requirement. I don't think the 22 years since Murray, there's any evidence that's happening. But if that were to happen in the case, I don't think the court is without a way to prevent that. One of the cases I cite is U.S. versus Dent from the First Circuit, and that was a lengthy discussion about egregious conduct, where if a court finds that the initial entry was so egregious, they won't even go to the let the Commonwealth get, or the government in that case, get to the independent source doctrine. So police officers are using this as a tool to get around the doctrine.
Mr. Farrader, you're starting to get very muffled, which I suspect may be your earplugs, just so you know.
I'm sorry. So what I was saying is I think there are tools if the court starts to find that officers are blatantly disregarding the warrant requirement to stop them, the government from even getting to the independent source doctrine, and that's from U.S. versus Dent, which has a lengthy discussion about a case Madrid from the 8th Circuit where officers under the guise of a protective sweep went through a house multiple times, went through papers and various things that you normally don't do during a protective sweep. In that case, the court said, we're not even going to let the government get to the independent source doctrine. The initial illegality is so egregious. Here, we're in a totally different circumstance. The initial illegal entry was not egregious. The officers did enter the home believing they had legal arrest warrants, and they had that probable cause reviewed and signed off on by a neutral magistrate.
Was that part of the findings that the officers believed that the arrest warrants had been issued?
Yeah, that is in Justice Fishman's. I believe he states that they went there believing they had an arrest warrant.
Can
the clerk had
Mr.
checked
Farrader,
probable cause. Sorry.
Back to the standard we should employ, because I'm getting confused now. So we have an inconsistency, at least between Pearson 1 and the federal standard. Does the Commonwealth want us to, because there is a possibility that a subjective police officer, this particular police officer wouldn't have sought it where, even though objectively another police officer would. So do we need, if we want to preserve this objective part of Pearson, to also have it be both a subjective and objective? It's back to Justice Lowey's hanging curveball.
Yeah, I think that's what the First Circuit expressed in Desher, that they really use a bit of both. And I think that's the right.
So do you want us just to adopt the way the First Circuit has done it, which is a subjective standard evaluated based on objective circumstances? Is that what you're requesting that we do as well?
Yes, I think that makes sense because of the hypothetical nature of the question that's being asked. Using purely subjective would be very difficult and not taking into account the totality of the circumstances. Because you're trying to answer something. You're trying to find something subjective intent that didn't actually occur, which is kind of difficult in this case.
So if we don't agree with you that that the defendant waived it, should it go back to Superior Court for a hearing or what?
It would have to, I think, go back for a hearing on this issue because the judge would have then misapplied the law and didn't make a factual finding. If you don't think there's a finding on this issue, it should go back to the judge to make a finding. But in this case where it wasn't pled, I think the gap in the finding is because it wasn't pled below and it wasn't raised below. I think that's the issue for the.
I'm sorry, I'm having trouble understanding you. I think it is a little muffled.
I think the gap in the finding is because the defendant didn't make this challenge below, which is why there is a factual gap, which is why this is a waived issue and should be reviewed for substantial risk and come out the same way De Jesus did and the way Fernandez did more recently.
So basically your argument is waiver, not disagreement with the analysis otherwise of the defendant.
Correct.
Okay, thank you.
Any further questions?
No further questions. I'll rest of my brief and congratulations, Justice Lang.
Thank you, counsel.
Thank you.